how you are illegally deceived or compelled to transition from being a constitutional citizen to a statutory citizen resident by confusing the two contexts. We state throughout this memorandum that the definition of terms used are extremely important, and that when the government wants to usurp additional jurisdiction beyond what the Constitution authorizes, it starts by confusing and obfuscating the definition of the key terms. The court then uses this confusion and uncertainty to stretch their interpretation of legislation in order to expand government jurisdiction in what amounts to judge-made law. This in turn transforms a government of laws into a government of men in violation of the intent of the Constitution. See Marbury versus Madison, 5 U.S. 137, 1803. You will see in this section how this very process has been accomplished with the citizenship issue. The purpose of this section is therefore to 1. Provide definitions of the key and more common terms used by both the federal judiciary courts and the legislative branch in Title VIII so that you will no longer be deceived. And number 2. Show you how the government and the legal profession have obfuscated key citizenship terms over the years to expand their jurisdiction and control over Americans beyond what the United States of America's Constitution authorizes. The main prejudicial and usually invisible presumption that governments, courts, and judges make, which is most injurious to your rights, is the association between the word or words citizen and citizenship with the term domicile. Whenever either you or the government uses the word citizen, they are making the following presumptions. 1. That you maintain a domicile within their civil legislative jurisdiction. This means that if you are in a federal court, for instance, that you have a legal domicile on federal territory and not within the exclusive jurisdiction of any state of the Union. And 2, that you owe allegiance to them and are required as part of that allegiance to pay them tribute or tithes for the protection they afford. Nothing more than a RICO racketeering mafia organization, right? And 3, that you are qualified to participate in the affairs of the government as a voter or jurist, even though you may in fact not participate at that time. 14.1. Where the confusion over citizenship originates, trying to make constitutional and statutory context equivalent. The U.S. Supreme Court identified where all the current confusion over citizenship comes from. Here is their explanation. Under our own system of polity, the term citizen implying the same or similar relations to the government and to society, which appertain to the term subject, in England is familiar to all. Under either system, the term used is designed to apply to man in his individual character and to his natural capacity, to a being or agent, public officer, possessing social and political rights and sustaining social, political, and moral obligations. It is in this exception only, therefore, that the term citizen in the Articles of the Constitution can be received and understood. When distributing the judicial power, that article extends it to a controversies between citizens or different states. This must mean the natural physical being composing those separate communities, and can by no violence of interpretation be made to signify artificial, incorporeal, theoretical, and invisible creations. A corporation, therefore, being not a natural person, but a mere creature of the mind, invisible and intangible, cannot be a citizen of a state, or of the United States, and cannot fall within the terms or or the power of the above-mentioned articles, and can therefore neither plead nor be impleaded in the courts of the United States. Sir Edward Coke has declared that the corporation cannot commit treason, felony, or other crime. Neither is it capable of suffering a traitorous or felon's punishment, for it is not liable to corporeal penalties, that it can perform nor personal duties, for it cannot take an oath for the due execution of an office. Neither can it be arrested or committed to prison for its existence being ideal. No man can arrest it, neither can it be excommunicated, for it has no soul, S-O-U-L. But these doctrines of Lord Coke were founded upon an apprehension of the law now treated as antiquated and obsolete. His lordship did not anticipate an improvement by which a corporation could be transferred into a citizen, and by that transformation be given a physical existence, and endowed with soul, S-O-U-L, and body too. The incongruities here attempted to be shown as necessarily described from the decision of the case of Bank of the United States versus Devox, and of Cincinnati and Louisville Railroad Company versus Letson, afford some illustrations of the effects which must ever follow a departure from the settled principles of the law. These principles are always traceable to a wise and deeply founded experience. They are therefore ever consensuous and in harmony with themselves and with reason, and whenever abandoned as guides to the judicial course, the aberration must lead to the bewildering uncertainty and confusion. Rundle versus Delaware and Raritan Canal Company, 55 U.S. 80, 99, 1852, from dissenting opinion by Justice Daniel. The confusion of the constitutional and statutory context is the origin of why we say that lawyers speak with forked tongues, like a snake. Snakes have two forks on their tongue, and they are the origin of the fall of Adam and Eve. One fork of the tongue is the constitutional context, and the other fork is the statutory context. The purpose of confusing the two contexts is to dissimulate people and make them falsely look like public officers that the government has jurisdiction over. Dissimulate, or dissimulated, or dissimulating, a transitive verb, to hide under a false appearance. Smiled to dissimulate her urgency, Alice Glenday. Merriam-Webster's Online Dictionary 2014 is the source. Dissimulating people in a legal context requires the following on the part of the audience who are being deceived. 1. Legal ignorance. 2. Laziness or complacency that makes the observer not want to investigate the meaning of the terms used. And 3. A willingness to engage in false presumptions, all of which are a violation of due process of law if employed in a court of law. The above devious form of explanation may be why the court have said on this subject matter, the chief enemies of Republican freedom are mental sloth, conformity, bigotry, superstition, credulity, monopoly in the market of ideas, and utter behinged ignorance. The greatest menace to freedom is an inherent, passive, ignorant, and uneducated people who refuse, as jurists and voters and active citizens, to expose and punish evil in our government. Whitney versus California, 274 U.S. 357. This case was had in 1927. What thieves in what Mark Twain calls the District of Criminals have done to perpetuate, expand, and commercialize the deliberate confusion caused by trying to make constitutional and statutory citizens equal is to essentially 1. Use the term United States in general sense and never distinguish which of the 4 United States they mean in every specific context. According to the following maxims of law, this amounts to constructive fraud. A deceiver deals in generals. Fraud lies hid in general expression. A general expression implies nothing certain. Where a thing is concealed generally, this exception arises, that there shall be nothing contrary to the law and right. Bouvier's Maxims of Law, 1856. On government forms, exploit the ignorance of the average Americans by telling them the United States they mean is states of the Union, even though the opposite is technically true. For instance, tell them in untrustworthy publications or on the phone support that it means the country. The following proves that all government publications and even phone support is untrustworthy, according to the courts and even the agencies themselves. This lack of accountability is strong motivation to lie with impunity to increase revenue from illegal revenue collection. When the government receives your completed form or application, silently presume the statutory meaning of the United States, meaning the federal zone of the United States, Title 28, 3002, 15A, is used everywhere on the form. Classify any and all documents and records that would allow people to distinguish the two above contexts, including especially the CSP code in your Social Security records. See Section 14.13 later. Create statutory franchises, benefits, under which all statutory persons, citizens, and residents, inhabitants, are public officers or office holders of the United States Federal Corporation under Title 28, 3002, 15A, and its federal territories. Those participating then take on the character of the corporation they represent and are therefore indirectly federal corporations also. Ensure the franchises limit themselves to federal territory in their geographical definition, ergo Title 26 U.S.C. subsection 7701A9 and A10, and Title 4 U.S.C. subsection 110D to keep them lawful and constitutional. Fraudulently abuse the terms includes and including and lies in completely untrustworthy government publications to illegally extend the reach of the franchise extraterritorial into a constitutional state of the Union. The abuse of includes provides a defense of plausible deniability if the government is caught in the scam. In creating withholding or application forms for the illegally enforced franchise, ensure that that there are no status blocks for those who don't want to participate or are under criminal duress to participate. Refuse to clarify or distinguish constitutional citizens from statutory citizens on the status block and only offer one option, U.S. citizen, which is then presumed to be a statutory and not constitutional citizen. Offer no forms to quit the franchise, but fraudulently call it voluntary. It can't be voluntary unless you have a way to quit. Tell people who want to quit that the computer or the form won't allow you to quit, even though the regulations or law requires them to offer you that option. Illegally penalize or discriminate against people who fill the form out properly by indicating that they aren't eligible, are under criminal duress, and are being tampered with as a federal witness to fill out the form in such a way that it fraudulently appears that they consent to the franchise and are eligible. For instance, if they won't consent to be a public officer called a taxpayer or a citizen or a resident or an inhabitant, tell them as a private company that you can't or won't do business with them. For details of the above criminal abuse of government forms to compel violations of the First Amendment right to not contract or associate, lie with impunity on the IRS website and in IRS publications and on the IRS 800 line about the unlawful confusion of context. When the above doesn't work and people figure out the trick, illegally penalizing non-resident, non-persons not subject to the Internal Revenue Code, IRC, for not criminally declaring themselves as statutory persons, individuals, citizens, and residents or inhabitants on withholding forms. This is criminal witness tampering because all such forms are signed under the pains and penalties of perjury. Bribe constitutional states to act like statutory states and federal corporations in exchange for a share of the plunder deriving from the illegal enforcement of tax code franchises. This causes them to help the national government essentially engage in an act of international commercial terrorism within their borders in violation of Article 4, Section 4 of the United States Constitution for America. This requires them to, 1, use all the same tactics documented here in state courts and state statutes, and 2, use driver's licenses as a way to essentially turn drivers into federal public officers or office holders by mandating use of the Social Security number available only to federal territorial domiciliaries for criminally and illegally bribe judges with financial rewards for sanctions or convicting people who litigate to stop the above criminal activity. See Title 5 U.S.C. subsection 4502 through 4505, Title 18 U.S.C. subsection 201, 208, 210, and 211 in court. Judges under financial duress refuse to clarify which of the two citizens they are talking about in court rulings so that everyone will think they are the same. Judges abuse choice of law rules to apply foreign statutory franchise codes to places they do not apply. Treat everyone as though they are franchisees, statutory taxpayers, spouses, drivers, whether they want to be or not. This is criminal identity theft and violates the Declaratory Judgment Act of Title 28 U.S.C. subsection 2201A. When challenged to clarify the fact that you have been improperly confused with statutory citizen and public officer or office holder as a state citizen, call your challenge frivolous, which in and of itself is malicious abuse of legal process and violations of due process of law if not proven with evidence to a jury of this disinterested peers. Gag attorneys with attorney licensing so that their livelihood will be destroyed if they try to expose or prosecute or remedy any of the above. Do this in spite of the fact that licensed attorneys are only required for those defending public office in the government. The ability to regulate or license exclusively private conduct is repugnant to the Constitution. Dumb down the public school and law school curricula so that the average person and average lawyer are not aware of the above and therefore can't raise it as an issue in court. When the above tactics are exposed on the internet, try to shut down the websites propagating them by prosecuting the whistleblowers for promoting abusive tax shelter under Title 26 U.S.C. subsection 6700, even though they are non-resident, non-person, not subject to the Internal Revenue Codes or the IRC, and can prove it. Slandering them with fraudulent accusations of being irrational and criminal sovereign citizens. The only reason any of the above works is because the average American remains ignorant and complacent about law and legal subject. The only thing necessary for evil to triumph is for good men to do nothing or to trust bad men to do the right thing. It is not good for a soul to be without knowledge. My people are destroyed for their lack of knowledge. We should no longer be children, tossed to and fro, and carried about with every wind of doctrine by the trickery of men, in the cunning craftiness of deceitful plotting, but, speaking the truth in love, may grow up in all things into him who is the head, Christ. One who turns his ear from hearing the law, God's law, or man's law, even his prayer is an abomination. The following subsection will go into greater depths about each of the above abuse to show how they are criminally perpetrated. This will allow you to get legal remedy in a court of law to correct them. How the confusion is generally perpetrated. Word of art, United States. The main method of perpetrating the confusion between statutory and constitutional contexts is a failure or refusal to distinguish which of the four specific meanings of the United States is implied in each use. We will cover how this is done in this section. It is very important to understand that there are three separate and distinct geographical contexts in which the term United States can be used, and each has a mutually exclusive and different meaning. These three geographical definitions of the United States were described by the U.S. Supreme Court in Hoven and Allison versus Yvette, 324 U.S. 652. The case was had in 1945. Graphical terms used throughout this page. United States, 1 asterisk, that country, United States, in the family of nations throughout the world. The United States with 2 asterisks, the federal zone, or Title 28, 3002, 15A. And then, of course, the United States with 3 asterisks, the collective states of the Union mentioned throughout the Constitution, supported by the Federation, all right, the Federalist Papers. In addition to the above geographical context, there is also a legal non-geographical context in which the term United States can be used, which is the government as a legal entity. Throughout this page and this website, we identify this context as the United States with 4 asterisks, or United States 4. The only types of person within this context are public offices within the national and not the state government. It is this context in which sources within the United States is used for the purposes of income and gross income with the Internal Revenue Code as proven by. The reason these contexts are not expressly distinguished in the statutes by the legislative branch or on government forms crafted by the executive branch is that they are the key mechanism by which federal jurisdiction is unlawfully enlarged by abusing presumption, which is a violation of due process of law. The separation of powers between states and the national government is destroyed in violation of the legislative intent of the Constitution. A society of law is transformed into a society of men in violation of Marbury versus Madison, Title 5 U.S. 137, 1803. The government of the United States has been emphatically termed a government of laws and not of men. I will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. Marbury versus Madison, 5 U.S.C. 137, 163, 1803 was the year the case was had. Exclusively private rights are transformed into public rights in a process we call invisible theft using presumption and words of art. Judges are unconstitutionally delegated undue discretion and arbitrary powers to unlawfully enlarge federal jurisdictions. The way a corrupted executive branch or judge accomplishes the above is to unconstitutionally presume that all of the 4 contexts for the United States are equivalent. 2. Presume that constitutional citizens and statutory citizens are equivalent under federal law. They are not. A constitutional citizen is a non-resident under federal civil law and not a statutory national and citizen of the United States at birth per Title 8 U.S.C. subsection 1401. Presume that nationality and domicile are equivalent. They are not. 4. Use the word citizenship in place of nationality or domicile and refuse to disclose which of the two they mean in every context. 5. Confuse the political constitutional meaning of the word with the civil statutory context. For instance, asking on government forms whether you are a political constitutional citizen and then falsely presuming that you are a statutory citizen under Title 8 U.S.C. subsection 1401. 6. Confuse the words domicile and residence, or impute either to you without satisfying the burden of proving that you expressly consented to it and thereby illegally kidnapped your civil legal identity against your will. One can have only one domicile, but many residents and both require your consent. 7. Add things or classes of things to the meaning of the statutory term that does not expressly appear in their definition in violation of the rules of statutory construction and interpretation. 8. Presume that statutory diversity of citizenship under Title 28 U.S.C. subsection 1332 and constitutional diversity of citizenship under Article 3, Section 2 of the United States Constitution for the United States of America are equivalent. 8.1. Statutory and constitutional diversity are not equal and, in fact, are mutually exclusive. 8.2. The statutory definition of state in Title 28 U.S.C. subsection 1332E is a federal territory. The definition of state in the Constitution is a state of the Union and not federal territory. 8.3. They try to increase this confusion by dismissing diversity cases where only diversity of residence domicile is implied, instead insisting on diversity of citizenship, and yet refusing to define whether they mean domicile or nationality when the term citizenship is invoked. See Lamb versus Betkins Van Lines, CO 139 F period, Superior period 2D 1300. 1314 MD Alabama 2001 to invoke removal jurisdiction on the basis of diversity. A notice of removal must distinctly and affirmatively allege each party's citizenship. A verments or negative averments of residence are wholly insufficient for the purpose of removal, although citizenship and residence may be interchangeable terms in common parlance. The existence of citizenship cannot be inferred from allegations of residence alone. Boy, that just screws with my eyeballs. So here's what we're going to do. All right. 9. Refuse to allow the jury to read the definitions in law and then give them the definition that is in conflict with the statutory definition. This substitutes the judge's will for what the law expressly says and hereby substitutes public policy for the written law. 10. Publish deceptive government publications that are in deliberate conflict with what the statutes define United States as, and then tell the public that they cannot rely on the publication. The IRS does this with all of their publications, and it is a fraud. This kind of arbitrary discretion is prohibited by the Constitution, as held by the U.S. Supreme Court. When we consider the nature and the theory of our institutions of government, the principle upon which they are supposed to rest, and review the history of their development, we are constrained to conclude that they do not mean to leave room for the play and action of purely personal and arbitrary power. Yick-Woo versus Hopkins, 118, U.S. 356, 369, 6 Superior SUP period, CT period, 1064 and 1071. Thomas Jefferson, our most revered founding father, precisely predicted the above abuse when he said, "It has long been my opinion, and I have never shrunk from its expression, that the germ of dissolution of our federal government is in the constitution of the federal judiciary. An irresponsible body for impeachment is scarcely a scarecrow, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless steps like a thief over the field of jurisdiction until all shall be usurped from the state, and the government be consolidated into one. To this I am opposed. Thomas Jefferson to Charles Hammond, 1821, 15 331. Oh, I blow my nose. My apologies. The judiciary of the United States is the subtle corpse of a sappers and miners constantly working underground to undermine the foundation of our confederated fabric. They are construing our Constitution from a coordination of a general and special government to a general and supreme one alone. This will lay all things at their feet, and they are too well versed in English law to forget the maximum. Boni judiciis est apleri jurisdictionem. It's in Latin. I will highlight copy and throw it over into a translator. Let's see what he is quoting here, shall we? Won't let me do it. All right. Thomas Jefferson to Thomas Ricci, 1820, ME, 15 297. When all governments, domestic and foreign, in little as in great things, shall be drawn to Washington as the center of all power, it will render powerless the checks provided of one government on another, and will become a venal and oppressive as the government from which we separated. Well, that's much of what's transpiring today. Thomas Jefferson to Charles Hammond, 1821, ME, 15 332. We see that exhibited by all this legislation that keeps things afloat, like the War Against Family under the Family Safe Care Act and the Interstate Acts and all this stuff, where the federal government encroaches into the states of the Union and then promises the actors that are supposed to be working on our behalf under the state constitutions, they incentivize them with federal funding and grants and money they don't have to pay back, so long as they will help convert the citizenry back over to the federal territory, right? And so that's what they're doing, and it's very grotesque. So basically, after the Act of 1871, everything came underneath the executive branch through executive order. The Congress now works for the executive division as a board of directors for the commander-in-chief. The judiciary now is fucking bean counters on behalf of the commander-in-chief, administering the largest bankruptcy, quite frankly, I think the world has ever fucking seen. All right, so they're all under the executive branch. They're all under the federal fucking government at this point. Nobody actually fills the true seats of office anymore. That's why the Cor Warranto is so powerful, because none of them actually are following the law. They're all lawless little bastards. All right? Let's continue on. Purpose for the confusion in laws and forms. The purpose for the deliberate obfuscation of citizenship terms is to accomplish a complete breakdown of the separation of powers between the constitutional states of the Union and the national government, and thus to compress us all into one big mass under a national government, just like the rest of the nations of the world. This form of corruption was predicted by Thomas Jefferson, one of the most revered founding fathers, when he said, "When all governments, domestic and foreign, and little as in great things, shall be drawn to Washington as the center of all power, it will render powerless the checks provided of one government on another, and will become a venal and oppressive as the government from which we separated." Is it going to go back into rhetorical shit? Fuck, I hate that. This is full of repetition, which is good for learning, but it gets aggravating. What an argumentation of the field for jobbing. Remember, jobbing is, to have a job is a criminal act. Go look up the word job. Hey, Butch, you want to go pull that bank job tomorrow? Jobbing is criminal. Speculating, plundering, office building, and office hunting would be produced by an assumption of all the state powers into the hands of the general government. Thomas Jefferson to Gideon Granger, 1800 ME 10:168. The great object of my fear is the federal judiciary, that body, like gravity, ever acting within noiseless foot and unalarming advance, gaining ground step by step and holding what it gains, is engulfing insidiously the special government into the jaws of that which feeds them. Thomas Jefferson to Spencer Roane, 1821, ME 15:326. The judiciary of the United States is the subtle corpse of sappers and miners constantly working underground to undermine the foundation of our Confederate fabric. They are construing our Constitution from a coordination of a general and special government to a general and supreme one alone. This will lay all things at their feet, and they are too well versed in English law to forget the maximum. Yeah, it's written in Latin. Thomas Jefferson to Thomas Ricci, 1820, ME 15:297. Now, it's important to know that Thomas Jefferson was very well versed in law. In fact, very well versed in admiralty law. And it's important to know those things. So when he's making these profound statements, it's not out of just blatant ignorance or a hypothecation that he has, or an epiphany that he's having. He was very well versed in law. It has long been my opinion, and I have never, I've already went through that one. Contrary to all correct examples, the federal judiciary are in the habit of going out of the question before them to throw an anchor ahead and grapple further hold for future advance of power. They are then, in fact, the corpse of sappers and miners steadily working to undermine the independent rights of the state and to consolidate all power in the hands of that government in which they have so important a freehold estate. Thomas Jefferson, Autobiography, 1821, ME 1:121. The system and diabolical plan to destroy the separation of powers and all the efforts to implement it are described. The purpose of abusing this confusion of context between constitutional and statutory citizens and residents is to 1. Avoid having to admit that you and not them are in charge, and that they are the servants and buyer, and you are the sovereign and seller. The seller or lender always wins under the UCC because he dictates the terms. In the United States, sovereignty resides in the people. The Congress cannot invoke the sovereign power of the people to override their will as thus declared. Perry versus U.S., 294, U.S., 330. This case happened in 1935. Strictly speaking, in our republican form of government, the absolute sovereignty of the nation is in the people of the nation, and the residuary sovereignty of each state, not granted to any of its public functionaries, is in the people of the state. 2 Dallas 471, Bovier's Law Dictionary, 1870. The ultimate authority resides in the people alone. The Federalist Papers, number 46, James Madison. A very great lawyer who wrote but a few years before the American Revolution seems to doubt whether the original contract of society had in any one instance been formally expressed at the first institution of a state. The American Revolution seems to have given birth to this new political phenomenon. In every state, a written constitution was formed and adopted by the people, both in their individual and sovereign capacities and character. By this means, the just distinction between the sovereignty and the government was rendered familiar to every intelligent mind. The former was found to reside in the people and to be unalienable from them. The latter in their servants and agents. By this means, also government was reduced to its elements. Its object was defined, its principles ascertained, its purpose limited and fixed, its structure organized, and the functions of every part of the machine so clearly designated as to prevent any interference so long as the limits of each were observed. Blackstone's commentary view of the Constitution of the United States, Section 2, Nature of the U.S. Constitution, Manner of its Adoption, as annotated by St. George Tucker, William Young Birch, and Abraham Small, c. 1803. Make them consent to become a statutory citizen invisible. So you aren't informed that you can withdraw it and thereby obligate them to protect your right to not consent and not be subject under their void for vagueness franchise codes. Remove your ability to civilly, politically, and legally disassociate with them peacefully and thereby abolish your sponsorship of them. Thus, indirectly, they are advocating lawlessness, violence, and anarchy because these violent forces are the only things left to remove their control over you if you can't lawfully do it peacefully. 4. Avoid having to be competitive and efficient like any other corporate business. Government is just a business, and the only thing it sells is protection. You aren't required to buy their product or be a customer. In their language, civil statutory citizens and residents are customers. You have a right not to contract with them for protection under the social compact. You have a First Amendment right to not associate with them and not be compelled to associate with them civilly. If you don't like their product, you have a right to fire them. To secure these inalienable rights to life, liberty, and the pursuit of happiness, governments are instituted among men, deriving their just power from the consent of the governed. Whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it and to institute new government, laying its foundations on such principles and organizing its power in such form as to them shall seem most likely to affect their safety and happiness. Thomas Jefferson. Declaration of Independence, 1776, ME 1:29, Papers 1:429. The only peaceful means to alter or abolish them is to stop subsidizing them and thereby take away all the power they have, which is primarily commercial. Any other means requires violence. Make everything they do into essentially an adhesion contract. There, where the civil statutory law is the contract. Adhesion contract. Standardized contracts form offered to customers of government goods and services on essentially take it or leave it basis without affording consumers realistic opportunity to bargain, and under such conditions that consumer cannot obtain desired product or services except by acquiescing in the informed contract. Distinctive features of adhesion contracts is that weaker party has no realistic choice as to its terms. Cubic Corp versus Marty, 4th District, 185 CA 3D 438 229. Call RPTR 828-833. Standard Oil Co. of California versus Perkins, CA or 347 F.2D 379-383, recognizing that these contracts are not the result of traditionally bargained contracts. The trend is to relieve parties from erroneous conditions imposed by such contracts. However, not every such contract is unconscionable. Leshim Tire and Sale Co. versus Berwick, 360 Mass, 718, 720, 721, 277, N period, E period, 2D period, 503. Blackstall Dictionary, 6th edition, page 40. Replace the citizen-government relationship with the employee-employer relationship. All statutory citizens are public offices in the government, as Judge Napolitano likes to say in his Freedom Watch program, Fox News. Do we work for the government, or does the government work for us? If you would like, destroy the separation between private man and public offices, and thus to impose the duties of a public office against the will of those who do not consent in violation of the 13th Amendment. Destroy the separation of powers between the federal government and the state. Undermine the very function of government, which is to protect private, unalienable, constitutionally protected rights. The first step in that process is to prevent them from being converted to public office or public rights or statutory civil rights or protections with your express informed consent. Hence, this is not government activity, but private activity of private corporations and mafia protection racket. 10. Protect the plausible deniability of those who are engaged in it by allowing them to disingenuously say that it was an innocent or ignorant mistake. Ignorance of the law is not an excuse in criminal violations of these kinds. 14. Obfuscated federal definitions confuse statutory context with constitutional context when we come back. Beyond the above authorities, we then tried to locate credible legal authorities that explain the distinctions between the constitutional context and the statutory context for the term United States. The basic deception results from the following. When we come back, I'll give you, I'll just give you the three now. There's only three of them, all right? The difference in meaning of the term United States between the U.S. Constitution and federal statutes. The term United States, with 3 asterisks, is the Constitution means the collective 50 states of the Union, the United States of America, while in the federal statutes, the term United States with 2 asterisks means the federal zone. Okay, now, for those of you watching, when you go look at the Constitution, you're not going to see a single asterisk and double asterisk and triple asterisk. That's how these people are identifying it within said document to give it the context, all right? 2. Difference between citizenship definition found in Title 8, the Alien and Nationality Code, and those found in Title 26 of the Internal Revenue Code. The term non-resident alien, as used in Title 26, for instance, does not appear anywhere in Title 8, but is the equivalent of the term national found in Title 8 USC subsection 1101A21, but not national, and citizen of the United States, District of Columbia in Title 8 USC subsection 1401. Now, I want to say this too. I went to verify a lot of this information, okay? I don't just read this shit and then believe it to be so. I went and looked at Title 8. And one thing that I found very interesting about Title 8 is they are now repealing and moving a lot of Title 8. Most of Title 8 is gone. And then when you go to where they say they moved it to, it hasn't been moved, or somebody's fucking eating brownies and smoking dope and not doing their fucking job, which wouldn't surprise me considering that that's what they do. They traffic humans, they traffic children, they smoke dope, they move cocaine, they move heroin, they bring fucking fentanyl into our country, they poison our fucking people because they practice mass genocide and extort and abuse the lawful American peaceful inhabitants in this country. 3. Difference between statutory citizen definition and the language of the courts. The language of the courts is independent from the statutory definition, so that it is difficult to correlate the term the courts are using and the related statutory definition. We will include in this section separate definitions for the statute and the courts to make these distinctions clear in your mind. When we come back, we'll hit up the distinctions between the court